Good evening, everybody. Good evening. Welcome to this webinar from TEMS Bangalore. It's a pleasure having you all here. Some of you are from other parts of the world, so good afternoon and good morning, wherever you are. So it's a pleasure to have you all come and look at discussing open source licensing. So open source is something which is part of our life, particularly those in the software domain. I think this is something which is becoming an increasingly large part of what we do. And we're glad to be having with us Prashanth Shivadass, a very eminent lawyer in this field, to come and talk to us about that. Before we get started with the webinar, I'll just take a couple of minutes to set the context and maybe introduce TEMS to those who are not familiar with this. So I'll just take a minute and let me share the screen. Right. So IEEE, for those who are not familiar with that, and if there are people from the legal fraternity here today, it might give some information. And for those who are from IEEE, welcome again. IEEE is one of the world's largest organizations of professionals dedicated to advanced technology for humanity. Right. So this is generally, the people who are members of IEEE are those who come from the electrical, electronics, or the broader IT field, and they work on creating new specifications, new standards, as well as advancing knowledge in these fields, and in a way that will actually benefit humanity. That's a very broad mandate for IEEE. It's been around for a very long time, started in 1884, and hence it's got a very long and storied history with a lot of accomplishments to its credit. One of the wings within IEEE is called TEMS, Technology and Engineering Management Society. This wing within IEEE looks at the broader aspects of how technology can be enhanced for delivering better services to society, how products and services can be converted into things which will actually be of value to society, how entrepreneurship can be fostered across the entire ecosystem, how ideas can be converted into products, and the broader stories around that. One of the things about managing technology today is about how we can manage aspects of compliance, licensing, and so on. And today's webinar is with that context in mind. So open source is something which has been an essential part of our life. There was a survey done, I think this was actually about a couple of years ago, and they scanned about 1,500 different applications from a variety of enterprises and found that nearly 96%, pretty much everything, had some kind of open source component or the other inside them. Right. And in fact, even within those, it's not just the presence of open source, it's also the extent of presence of open source in these products, which is increasing. So it's now well in excess of, this was a couple of years ago, and there is no reason to believe that it is not progressing at the same pace. So very likely, more than 2/3 of every single application that is built today is having open source as its component, and then the remaining 1/3 sort of forms the actual application that is being built by those enterprises. So as you can see, open source forms an extremely strong foundation, an essential foundation on which nearly all applications and all software is built today. In fact, the number of components that are used in applications has shot up tremendously. This survey, there was another survey, this is from Black Duck. They are one of the larger proprietary tool provider in this space. And their assessment was that last year, the average number of open source components is in excess of 500. Right. So this might seem surprising. You may not explicitly use 500 different components yourself, but it's a cascading thing. You use certain open source components, they in turn use other open source components, and it kind of pulls in. I mean, anybody who's built anything with Node or React or worked in general in the JavaScript ecosystem will know that you can keep pulling in dozens and hundreds of NPMs with almost a single dependency being added, and so you can see how it shoots up very quickly. So with such a large portion of our application, of our industry in general, being based on open source, it's very important for us to understand how open source licensing plays a key role in this. So while I talk about this, there is a small poll that I would like to share with you. This just to understand what kind of background the people on the call are. So this should pop up on your screens. And if it does, please do respond. And we'll see the results as well. And I'll see if I can summarize that for Prashanth. So while you respond, I'll just continue on. So there is a very wide variety of licenses that are being used. So open source licenses, at least in the context that we're talking about, we kind of think about it as a monolithic single thing that we need to understand. Unfortunately, that's really not the case. Right? There are hundreds of different licenses, and there's a very wide variety of obligations, rights, and restrictions they all come with. And understanding them will make us better developers, better engineers, better managers, and better business unit heads, because understanding licensing is extremely crucial to running a successful software product today. My own awareness of open source licensing goes back some 17 or 18 years, when we were building a product which was getting licensed by a large semiconductor manufacturer. And one of the requirements that they had on us to purchase that license was they needed us to provide a list of open source licenses and which components that we use. And that's when we started realizing that even doing regular business might actually require us to be careful about what licenses we use and how we understand and interpret them, and how we meet our obligations under each of those things. So my interest goes back a long way, and but the open source licensing domain hasn't been very static, so it's evolving as well, and there are hundreds of different licenses, and we will hopefully cover the more important ones today. So I have the results, or at least those who have responded back. The bulk of them, well, the 41% say that I understand there are different licenses, but don't do anything about them. So the good thing is that there is the largest number of people do understand that there are licenses and there are different variations, but don't do. And hopefully today's webinar will help them act upon them. The next 35% say that, Prashanth, that they understand the licenses and my rights, and sometimes comply with them. And hopefully, again, today's webinar will help you comply. There are few people who say that they don't really understand this stuff, so it gives us some perspective of where they come from. And there are about 4 people who say that they understand the licenses very well and comply with every detail of them. So those are likely to be our experts as well, and hopefully they will contribute to this discussion as we go along. So thank you for your responses. That does give us a good idea of who are listening in. So like I said, there are lots of different licenses, and this is from Synopsys. These are the top 10 licenses being used in our work. MIT and GPL obviously are the 2 big ones, and there's a lot of them. And they also have an assessment of what forms a risk, which are the ones which come with certain higher level of obligation, which you need to do something about, while the ones which are low, typically put a smaller constraint on how you can use the products which come under those licenses. And that gives you some sense of which are the top ones at play here. Right. So I have one more poll just to get a sense of, since there's a large number of people who do understand these licenses, so let me just share the next poll, and do pick the ones which you think you are using, or which one you are aware of. And this is a list of licenses that should be available on your screen now. And pick as many as you want, the ones that give us a sense of which are the most popular licenses that you are using, and would help us in framing the question subsequently. So I just give another 30 seconds for the responses to come in. At the moment, MIT and GPL seem to be winning, if the winning is the right term, and that kind of reflects what this survey did. So, right. So at the moment, MIT is almost 64% of people say they use MIT license, Prashanth. So that gives some sense. Almost 2/3 of the participants use that license, while about 57% use GPL. So very close behind, but those 2 seem to be the biggest ones. Apache is a third with about 43% of people using those licenses. So thanks everybody. Thanks for your responses. Again, that does give us a good flavor of what you're using these licenses, what kind of licenses you use. So that, given the extent of these licenses and the open source adoption and software in general, and how important a foundation they are for everything we are doing, we thought from IEEE TEMS that we should have a expert in this domain come and talk to us about this, help us understand in all our multiple roles, and help us get more compliant to these licenses. So when I first approached Prashanth, this was about a month ago or so, he very readily agreed. Thank you, Prashanth. Thanks for agreeing so readily to come and talk to us and educate us on this one. I'm an engineer, and most people on this call are going to be engineers. So it's really good to have a proper legal view. I do add this disclaimer that this will not be construed as legal advice, and I'm sure Prashanth will talk about it in a more legal way, but this is information which is meant to educate you, and I'm sure you will have your own sources of getting proper legal advice. So with that, let me introduce Prashanth. So he is an advocate and founder of Shivadass and Shivadass law chambers. He holds a distinction degree in computation law from Queen Mary University of London. He has advised domestic and international clients in a variety of areas. And he's not just an armchair lawyer, though he appears on Zoom right now, but he has appeared in over 1,000 commercial litigation corporate matters for clients in front of the Supreme Court of India and several high courts and other judicial fora. Prior to setting up Shivadass and Shivadass, the law chambers, Prashanth had worked with top law firms in India and abroad, including setting up practice verticals and offices in London, and has gained tremendous experience working with the Solicitor General of India for more than 10 years. Prashanth also delivers lectures at various symposia and on issues relating to antitrust, computation law, company law, data protection, and privacy laws. In fact, I believe just yesterday he was talking about, he was addressing another audience on data protection, and particularly how things like GDPR affect people and so on. He is a seasoned lecturer at various business and management schools, not to mention leading law schools in India and abroad. Beyond law, he's also a trained classical singer, 20 years, a state-level cricket player, and a casual photographer, and also the winner of the award for in the Legal 500 for antitrust and competition law in 2017 and 19. It's a pleasure to have you here, Prashanth. Welcome once again to this forum, and look forward to hearing from you and educating ourselves on how this open source licensing
should. Thank you, Arun. Thank you for this very, very, very kind introduction. And good morning, good afternoon, good evening to everybody who's joining in. Very kind for Arun to have explained the topic in brief. I must confess, I'm not as good and smart with technology as all of you are. So my knowledge on technology is not as much as all of you. But I will definitely try and hope that I'm able to bring in some input on the table. I was quite intrigued when I saw those polls, and I'm trying to see if I can bring up those polls again. And
is this something that you want? Yeah.
Yes. So I've gotten hold of the first poll, the awareness of false licenses. And I see, as Arun mentioned, about 42% of all of you know what different licenses you need, but don't. I'm not able to read the entire portion of it, Arun.
So which one? The first one? Or?
The second one, the 42%. Oh, yes. Okay. There are different licenses, but don't do anything about them. Yeah. What does the second part really entail?
Right. So it means that, their obligations, their rights, they are not able to necessarily honor those things. So it's sometimes you need to do, show or notice or share the source code as an obligation to use a component. And hence, people might use the license or the component, but not necessarily follow up on those obligations.
Okay, so I'm sure that I'm actually catering to 42, 32, and 5. And the remaining 21% will excuse me if I make some mistakes today. And insofar as the second poll is concerned, which is quite surprising on its own, I see that 64% of the people, and the second highest is 57. So there are completely two contradictory licenses that people are really opting for today, because MIT, as I understand, is a permissive license. Yep. And GPL2 is something known as a copyleft license. So there are two extreme licenses that people are actually picking up. So this is quite intriguing as well. And to be fairly honest, I didn't know that Zoom had this poll in the first place. So this is a good thing for all of us as well, because as lawyers, we all know only to log in and do nothing else with Zoom. So this is quite interesting. Thank you so much for this. This gives us a good background as to how we can go ahead with the webinar and the Q&A today. So thank you so much for this poll as well. To all of those who are joining us, I don't think I need to explain what FOST is, and I think Arun will take care of that. But what I was interested to note was that almost 528 open source softwares are used in a single application. Wow, these are great numbers. And from what I see, I think the growth has been over 200% in the last 5 years. So there has been a lot of talk about FOSS and open source softwares and how these are to be licensed, especially with data protection coming in. And like people mentioned, IP is not done and dusted, but still data protection is something that's picking up. So a lot of people will have trouble with all of this as well. So I leave it to Arun to see how we can take this forward. I know we've received a few questions. So rather than making this a monologue and make it boring at 7 p.m. in the evening India time, I thought it would be better if we can have a fruitful discussion. So I'll give it back to Arun, and maybe we can have a short Q&A session, and then we can always pick up questions from the participant. I hope that's okay, Arun.
Perfect. I think that's perfect. So let me. So I would request, I will start with a set of questions for Prashanth, just to get the ball rolling and answer some of the doubts that I myself have. And
sure.
If any of you have any questions, feel free to post them using the Q&A. The Q&A would be the best way to do that. You should see the Q&A option on your screens. Please do use that and submit your questions. And I will pick them up and relay them to Prashanth as we go along. So feel free to ask any question that you have on this topic. I'm sure there'll be plenty. So while the audience thinks about their questions and so on, like you mentioned, GPL is a copyleft license and the MIT is a permissive kind of a license. Would you want to elaborate that a little bit more and give us a flavor of what those two differences are and get that going?
Sure. I'm not sure what is the background with which all of the panelists, all of the participants today have joined in insofar as IP law and licensing is concerned. But just as a backtrack to it, generally, if you have a copyright or a patent or a trademark, etc., and you license something out, the normal nomenclature that is associated with licensing is a royalty fee or some kind of a fee that is associated with the licensing product, unless, of course, the two parties have sat down together and decided that, listen, I don't want any license fee or royalty, or that the patent or the copyright has sort of expired on its own track and you only have author's rights. And that's something that's available to a lot of the people who start off. In that sense, if you look at FOSS or even OSS for that matter, and I'll begin with OSS to give a clear understanding of what permissive could be vis-a-vis copyleft. Free open source software and open source software, and that's how the split happens. And the word that's key here is the term free. So in an open source software, while it is open and available for everybody to use, you still have to have a permissive license because it relays the kind of extraction and kind of derivatives that you can use from that open source software. In that sense, if you put in everything as part of your licensing agreement and you say, listen, you can do 1, 2, 3, 4, 5, 6 things, and you can't do 1, 2, 3, 4, 5, 6 things, that makes things clear, which is why when the poll popped up saying MIT is 67%, I understand why people have opted for MIT, because that makes more sense for them because they have a clear understanding of what needs to be done with the license itself. Whereas on the other hand, if you look at free open source software, and if you look at, for instance, the general license, which is otherwise known as a copyleft license, the copyleft also has two strong wings to it, a weak copyleft and a strong copyleft, right? And for those of you who don't know, this is not an opposite of copyright. A copyleft is a stream and a method in which some licensing requirements may happen. But the problem with copyleft and general public licenses in that regard is that the restrictions are far more than what they usually are in a compulsory license in that sense. Or for that matter, when I termed it initially, they are actually known as permissive licenses. So if you look at the general public license, there are 3 versions or 4 versions that have come out so far, and people tend to operate on those 3-4 licenses. The problem, or I wouldn't say it's a problem, but the issue with a general public license is that everything has to be made available for free, and you have to use the code that comes to you as it is throughout the chain that you follow thereafter. And once you get into a general public license, you have to follow that model throughout. So in the sense, if the first creator comes out with a FOSS, and then the second creator takes it over, he has to follow the FOSS as it is, and he can't make any modifications to that FOSS. He can make his own modification using that FOSS to create something else, but he can't make modifications to the first original FOSS. OSS, on the other hand, with permissible licenses, has that little bit of the leeway and option to tweak that modification a little bit. But then again, you don't touch the copyright of the first OSS. You only get a copyright for what you create using that OSS. So that's the sort of essential difference between a permissive license and a copyleft.
Yeah, thanks, Prashanth. Thanks. There is a notion that when you distribute a derivative work, that there is you need to follow certain compliances or to follow certain obligations and so on. So, what constitutes a derivative work in this language, in the licensed language, actually?
In legal parlance, Arun, derivative is a very large context. What happens in a derivative work in general IP law is that suppose you have a patent for a manufacture of a certain kind of a drug, right? Now the patent has XYZ components, and using the X component, you draw it out and you make something else, which is a lower capacity than what it is on how the first original drug actually works. So the derivative product is usually a derivation, and in mathematical terms or physics terms, we all know how derivation really works. So a derivation is really a strip down from what the original component is, and then you move forward. Now, in an open source software or in a FOSS, you can't really create a derivative in that sense because you can't strip down an OSS or a FOSS. You can only add, modify, or you can use the OSS or the FOSS as it is to create something else. But a lot of people have really sat down and figured out what a derivation really means. And now we know for a fact that there are certain portions of the original FOSS and the original OSS that can be used in a modified manner, but really it doesn't really constitute a derivative in that sense. So there is a little bit of a fulcrum on how derivative really works. But in that sense, any work that is drawn out from the original FOSS or the OSS can be termed as a derivative for the legal sense.
All right. Okay. So if I interpret that, then I would imagine that any modification done to the original one would constitute a derivative.
Yes. Yes. That's the context in which the legal understanding works.
All right. All right. So there's actually a bunch of questions I'm trying to answer.
I saw that on the Q&A box. So what I'll do is I'll place you also on the screen so that we can be at par at each other, and then we look at the questions together. Let me just see if I can remove the spotlight. That's great. That's perfect. Thank you. Like I said, very bad with technology.
Oh, that's all right. So no, that's my job actually. So so this is from Kaushik. So he asks, what are the
strategies that can be used, especially with respect to static linking, dynamic linking, and other approaches that can be used if a restrictive license need to be used? I don't know, Kaushik, if you can talk, and that I think will live.
There's no audio.
There's no audio. Okay. I wanted to understand, Arun, what is static and dynamic linking?
Right. So especially, I'm just reading the. Right. So especially when in this context, the way Kaushik is asking, and I'm giving a technical interpretation of that so that you can answer the legal last. So when a software in the context of the derivation that we were talking about a few minutes ago, so you could have a piece of open source license component which is integrated into some other larger piece of software.
Okay.
Right. And now that integration can happen as, for example, today you use, like Zoom, as this is one single, application that you run. So everything that is used in that is part of that one single, just called statically linked. So it's bundled into that application. While there are some other places where you would have different components they are present, you would not necessarily make them as part of your product, but they are required to be present in order for your product to work. Right, so that would sort of make it a loosely coupled kind of a component. So your product needs to be there, but it's not shipped as part of your product in a way, right? That's where the static dynamic linking would come in. I mean, very
yeah. Sure. So his question then comes to avoid opening up of our complete source code. Right. Now that is something that that caught my eye as well when I was reading up on all of these things, because if you're using a source code that you develop on your own, then it becomes your own source code and your own copyright, right? But we're not in this webinar, at least, I don't think this course source code would mean FOSS or OSS, because if it is FOSS or OSS that is going to be used in say, I'm assuming it's a commercial product that needs to be sold out eventually. If it's a FOSS or an OSS that needs to be used, then it mandates that the person who's using that FOSS or the OSS to make a commercial product needs to mention the original source code from where it has been picked up. And that's a requirement of FOSS and OSS. So you can't avoid opening up of the complete source code. But if it is a proprietary source code, then that's fine, because then you are the owner of that source code. So that will be okay. But if you're using FOSS to make a new complete product and you want to sell that product, then till the developer stage, at least you will have to disclose the FOSS source code that you've used.
Right. Thanks, Prashanth. If I can add a little bit to that answer, Kaushik, thanks for clarifying in the subsequent message. So, if you use a LGPL based component, then clearly, you don't need to open up your source code, and that's part of how the LGPL, in fact, was created. So any LGPL component that gets linked either statically or otherwise, you don't need to open up your application source code, and I think you are well covered on that front. However, if you are using GPL and if you do a static linking, then there isn't really any option other than to open up your application source code. So in that sense, those licenses come with those restrictions, and there's no easy way to work around that, because those licenses are created explicitly to avoid use of GPL component in a closed source product. So in that sense, they explicitly try to prevent that. So I'm not sure there's a quick way or easy way to, or a strategy that you can use to overcome that part of it. Prashanth, I hope that's all right if I can just...
Perfectly fine.
Yeah, Kaushik, I hope that answers your question. You can ask a follow-up in case you wish to. The second one is from Slicer. Can I read the question, or do you want to read it?
Sure. Absolutely fine. I keep hearing about the term portions copyright to be included in about box. Can you please explain the term a little more? And I am assuming portions copyright in your context would mean the portion of the copyright that you've used apart from the FOSS that you've already used to make a new product out of it. So if I'm getting a FOSS A, I put a B into it, and the B that I put into that FOSS A becomes product C at the end of it all. Right. So the portion that I put, the B that I put into the FOSS A, that B is the copyright that I generate and I create. Now, in some in some countries, you don't need to specifically make an application for the registration of a copyright. It is automatic. For instance, India has that, Australia has that. So you don't really need to make an application for you to have a copyright on it. But some countries, for instance, the US, you need to make an application for you to get that copyright. So for that portion alone, which you've added to an existing FOSS, that portion alone is known as a portions copyright.
Thanks, Prashanth. Slicer, in case that was, if you had some other interpretation of that question, please do post a follow-up, and we'll be happy to take that up. Deepak is asking, and this falls in a very legal context, so you might be...
Indemnification clause, how does it work in case of using third-party open source? SW, I would assume, is software. Yeah. A main software using a third-party open source, in case there is an indemnity claim on the main software due to third-party, then what is the limitation of this? Okay. Now, this is something that we get asked a lot. Now, this is where you have something known as a copyright notice. So the original person who owns the force. So let us assume I make the force, I give the force to Arun. Arun then gives it to Mr. Deepak Arora for him to make something else out of it. And Arun also makes something out of it. So the original force lies with me. In my license to Arun, I will have a copyright notice that says, hey, look, Arun, this is my software. You use it the way you want to because I have the copyright for it. But what you do with the software and what happens as a fallout of your software, that's your headache. Don't pin that on me. Arun then passes off that copyright notice as is to Mr. Deepak Arora, who will then use that and couple that out with other people as well. So this is where the chain of either a forced copyleft happens or an OSS compulsory happens. And you have to follow that chain throughout. So in that sense, Mr. Arora, if there is a third-party open source that you are taking in and you modify that third-party open source and supply it to somebody else, only you are obligated to sue the third-party open source in case there is a problem with the open source or there is a violation of the open source. Who you sell it to, that person has no right with the original third-party owner.
Yeah, thanks, Prashanth. Thanks a lot. If I could add a technical element to that answer, Prashanth, then so Deepak, one of the things that is needed to be done in such cases is also some kind of prior due diligence when you use the third-party open source software. So there are actually technical tools available which will do an audit of such software and then give you a sense of what open source elements are present in that, and then you can take a call based on that report on whether what is the risk that you are running, and do you want additional indemnification from the third party or not. But those tools will give you the information to take a proper a judgment call on that one. Prashanth, sorry, so that Kaushik has basically said that
no, just for his input, Arun, Kaushik's input.
Yeah.
If it is a proprietary source code, if it is your own source code, irrespective of the license, don't disclose it. You don't need to disclose it because it's called proprietary source code for a reason. So it belongs to you, so you don't need to disclose it unless you want to make it a force.
Right.
Unless you want to make it a force, you don't have to disclose your proprietary source code.
Right. Right. But in case, I imagine the context is if he's referring to integrating open source code. So essentially, it becomes, if you see that initial part, it would mean that it's not entirely proprietary. If it is entirely proprietary, what you just said would be
correct. But if he's referring to integrating an open source code and the proprietary source code, to the extent that he has used the open source code, that needs to be divulged. Proprietary source code can be kept aside.
Right. Okay. All right. Thanks. All right. Then there's a question on the chat. This is from Praveen. He is asking which license is applicable for educational purposes.
Generally, Arun, if you look at IP laws in that context, IP law exempts any kind of use of patents or trademarks or copyrights, etc., when it is used for educational purposes, because there's a concept of fair use. So if for some, when we used to be in law school initially, we never used to have access to books. So when a publisher sends one book to the law school, we used to take photocopies of that book and keep it with us. And we used to claim fair use because then it is being used for academical or educational purposes. So if it is used for educational purposes, if it is used for fair use purposes, and it's a very large definition, fair use is a very extensive and large definition. If it is used for fair use purposes, then you don't generally need any kind of license. In fact, all license agreement in themselves have a clause saying that if it is being used for fair use, then you don't have to take permission from us. But otherwise, you'll have to take permission from us in case you're licensing it or sub-licensing it to any other third party.
I see. So in general, the fair use protection should apply to educational institutions.
Yes.
So I hope, Praveen, that answers your question on this one. So there's actually a follow-up from Slicers saying that he will want to have a follow-up question, so I'll wait for that.
Sure.
Meanwhile, there are a few other questions that are there, which I will take up. So, how do let's say I'm using an open source license, and that license also implements some product or some idea which is patented. So how do these open source licenses coexist or interact with patents? Or how do they play off each other, and what kind of aspect should one consider?
There are two aspects to this question. One is, if you're, of course, if you're using a patented product, you always have a license with them, and therefore you have a royalty, etc. All of that works with the person from whom you picked it up from as a patent. So if I picked up a patent from you to license, sub-license, and use that product, etc., a development and use of that patent using that license is permissible to me. So what I will do is I will enter into a licensing agreement with you vis-a-vis the patent of yours, and I will pull down all of the rights and obligations I have vis-a-vis your patent, where I can't sell it commercially, I can't sell it, I can make a derivative work from it, etc., and use that as part of my licensing agreement. Now, when I have that licensing agreement with me on my table and I pick up an open source software, since the original licensing agreement with the patent holder allows me to create a derivative or modify, etc., once I make a modified, say, product or a software, that software by itself now belongs to me. So patent in itself means any improvisation on an existing product, because no product is very original in that sense. Everything is a derivative or a modification of an existing product. So any innovation of an existing product is also considered a patent. And you get a 60-year timeline. In India, at least, you get a 60-year timeline for a patent, right? So if I have that, and if I've used that in a certain way to make a derivative or make a modification, and then use an open source to make my product a whole, that's fine. That should not be a problem. And those two things will interact with each other. But eventually, when I have the product and now I license it out to somebody else, I will have to have a good license and a strong licensing agreement with the person that I give it out to, because now it has a wholly patented product in it. I think you're on mute, Arun. Yes.
Right. So I think so. Then it needs extra protection or precautions to be taken when handling.
Yes. And that's where your data protection angle, your other IP issues will all come in, because you're using a material, you're using data of somebody else to make your own particular data. And the GDPR has been quite stern on these actions. India so far does not have a data protection law yet. It's currently pending in the parliament, but GDPR is quite strong on these points.
Yeah, thanks. So there's a follow-up question from Slicer. It's more detailed.
Sorry, Rohit, you're right. Yes, the patent is 20, copyright is 60, not 50. Copyright is 60, and then you have author's rights. Patent is 20. I stand corrected.
Yeah. Thanks, Rohit. Thanks for that. For the diligent following of the discussion. Thanks for that.
Like I said, those 18% of the people will correct me today.
Yeah, we all get prizes. So there's a follow-up question from Slicer on the Q&A.
Yeah, since we use many open source components, I'm always worried about the third-party indemnity. I have signed as part of my license with a large customer of mine. How do I protect against some original developer suing my customer, okay, who is large, and it will help the developer some limelight, and I have to indemnify my large customer? I'm not sure how you have to indemnify your customer if he's, I'm doubtful if he can first of all sue the original developer in the first place, because he has no privity. There's something known as privity of contract. So he will have no privity of contract with the original developer. But in the case, in the off chance, very, very remote off chance that he does go ahead and sue the original developer, the original developer will simply come and show his copyright notice to court in saying that, listen, I sold mine to you, and you in turn sold it to your customer. So I have no role to play with it. If you have some problem, you deal with your person who's the person who sold it to you. So that's how it will work. So in that context, yes, you may have to indemnify your large customer, but there's no chance, or there's a very slim chance that the customer will go against the original developer to court.
Thanks, Prashant. Slicer, I hope that answers your question. And again, if there is something which you would want to follow up, please do raise a follow-up question, and we'll be happy.
I think there's a question from Deepak as well. Another question from Deepak, a follow-up question. It's on the chat box, so I'll just read that out. Follow-up question. As an example, we use an open source community edition database in our IPR software. There's an indemnity claim which occurred due to this community edition of the database. Will this database company be a party to this claim, or only our IP software has to take care of this claim? This needs a little bit more clarity, Deepak, because if you have used a community edition database to create your own IP software, then the community edition will not play a role here, because you are the person who used that community edition to make another IPR software, which is then rolled out to a Tom, Dick, and Harry. So what happens there is you are the person who's ultimately facing the customer, and therefore you will be the person who will take the claim and not the original party. Of course, in India, we tend to make everybody a party who right from the source code operator till the person who is buying it, everybody becomes a party in court, and then we go and file and say, listen, I'm not a party to this suit. But in a sense, the controversy will lie between you and the person you sold it to. I really hope that answers your question, because I may need a little more clarity on what you may need on this.
Yeah, thanks, Prashant. Deepak, if you have a follow-up, please do share it. And we'll see if there are other questions open. So no, I think you're answering them as fast as they're coming. Thanks, Prashant. So, you brought up this topic of copyright and in the opening remarks and talking about copyleft. So when someone makes a component open source, so who does the copyright belong to? Suppose I use that product. So does the copyright get transferred to me, or does it belong to the original user? So any thoughts on that?
So let me explain this by way of an example. If I am the person who's making the original FOSS in that sense, and I use XYZ material to make that FOSS, then the copyright of that original FOSS of XYZ belongs to me. Now I get into a licensing agreement with you, or whatever nature, and you now use that FOSS to create the data in the FOSS, which is XYZ, which is the code which I had created, and you add an A to it, right? Now, the XYZ still belongs to me. The A is something that you have developed, and therefore that copyright will belong to you. Now, the product is known as XYZA. You, in turn, will give it to somebody else in the form of a licensing agreement who adds a B to it. So insofar as XYZ is concerned, that's mine, A is yours, and whoever adds B belongs to the person who added that B. So the copyright chain goes in that extent to the level where what addition and what modifications and alterations have been made, that belongs to you. Otherwise, the original portion of it belongs to the person who gave it to you. You're on mute, Arun. Sorry.
Yeah, keep going on. Sorry about it. So thanks for that answer. That clarifies things quite well. So there's a follow-up from Kaushik. I think he's...
if I have 5 patents on my product specific set of functionality, and the software implementation of these functionality integrates open source together with my proprietary source code, then 2 questions: is the patent really valid? I don't think, why not? Because the patent is for the entire process that you've used. And free open source software in that sense is meant for things like this, because you pick up something from the internet, which is a free open source software, you do something with it, you integrate it with your own original source codes, etc. But you will not get a patent for the source codes. You will get a patent for the process that that software does, or that software uses, and that's how the whole patent will work. So I don't see why the patent should not be valid. And insofar as do I have to pay a royalty to the open source parties in case the patent is valid? No, there is no concept of royalty in so as it's known as open source parties. But there will be a one-time fee when you pick up the open source in the form of a license from the original person. There will be a one-time fee, and that one-time fee, of course, is subject to negotiation between both the parties. But that is the only fee that you will have to pay. There is no other royalty that is attached to that, because that open source, which ultimately becomes the final software or the product, is a completely different product from the original open source. So that product now belongs to you. Therefore, you have the right to do whatever you want with that product, subject to FRAND terms and whatever you want to call it.
Thanks, Prashanth. If I add a slight one more couple of lines to this one, Kaushik, I think the implementation itself is not what gets patented. It's really the idea. So in that sense, the fact that you are using an open source in the implementation is a later part of it. So the idea would have hopefully got patented before you get to the implementation or the realization of that idea. So hence, the idea is in that sense detached from how you would realize it. And presumably the idea is sufficiently novel that it builds sufficiently new value on top of what the open source you are trying to build upon. So just additional information for you on that. All right. Rohit has a comment here that softwares are...
That's right. Softwares per se are not subject. That's what I meant, because the software essentially holds a source code, and a source code by itself cannot be patented. That is because that is only subject to a copyright. But the process in which you arrived at that can be patented.
Thank you. Thanks a lot. That clarifies things. So, are there, we are coming close to we're about 5-6 minutes away. And so is there a sense of open source? Is there a particular license type or do you see a direction in which these open source licenses are heading in the coming days? Is there some general trend that you see on around these?
I think the poll answered that question in a certain way. I think most people are now looking to take MITs or I would believe Apaches are one of those licenses where the permissive licensing model is the model that's really picking up these days, because you can really put down and pin down what you need to do and what you should not do as part of that permissive license, which is otherwise not available in a general public license, in a copyleft license. So I do see a growing trend of permissive licenses being used. And with time, I think there will be stricter licenses that are going to be introduced. And I think parties will have more of a leeway in terms of what they need to put down as part of that as part of that license. So there is some kind of a methodology in which parties come down and sit together when they sit down and do MIT or Apache, etc. But that gives them more freedom to work around with the source code itself.
Thank you. Thanks a lot. I think so the direction is pretty clear in that
yes.
sense. Yeah. All right. So are there any other questions, as we are coming close to wrapping up? So if there are any questions, please do raise it right away using either the Q&A or the chat. You can see both. So Prashanth has been knocking the questions off the park as soon as they come in. His cricket
So, no, this was a prime example of how India collapsed yesterday.
Oh yeah, yeah, not a So do you see a need for increasing awareness of open source licensing within the legal fraternity as well? I mean, I'm sure there are plenty of people who specialize in those areas and all that, but do you see increasing, as we see in our technical community, a need for increasing awareness of the legal aspects of licensing? Do you see a similar thing on the other side as well, actually?
To be honest, I think the legal sector may not be as the problem lies in two different ways, Arun. One is, I think the legal guys are not really interested in how the software really works and how, because for me to understand FOSS and OSS, it really took me a long time. So for us to figure things out is going to be difficult. But at the end of the day, I think when it goes to a context of patent and copyright and how the software really works, and that is where our angle really steps in. So the current generation of lawyers will really have a good knowledge and know-how of all of this. But if you look at perhaps a pre-90 era or an 85-90 era, they may not have this much of a knowledge on OSSs or even FOSS for that matter. So yes, there definitely legal fraternity needs to have more insights on all of these things.
Okay, that's great. I mean, as we see, there are many patent attorneys who specialize in certain domains. So probably there'll be open source licensing attorneys at some point.
And truth be told, I think for in India at least, for you to become, or I think this exists almost everywhere, for you to be a patent attorney, you also need to have a science background.
Right.
And I quit science way back in 8th grade. So my knowledge of science in that text is very, very different. We're all commerce students. We move to arts sometimes. So it's very difficult for people to adjust to the technological changes that are happening these days.
Right. So there's one last question, which is a little bit outside the open source, but still kind of connected. Sure. While the FOSS licenses, the GPL and the LGPL, these are things which are relevant in the software context. Similarly, things like images and movies and videos, they come with the Creative Commons or similar licenses as well, with the similar intention that they can be shared and reused without giving royalty and things like that. So do you have any comments on how people are using them, or anything which you want people to become aware of on that kind of licensing? I mean, that's not a focus today, but that's something which is closely allied. I mean, it's as simple a thing as a PPT. You want to put a image. Are you allowed to use that image is a big question, and not sure everybody thinks through in that sense, actually. So
so if you're looking for a legal terminology, it's called plagiarism. And we don't have a legislation yet in India, but there are legislations in UK, for instance, even for that matter, some of the countries within the EU who have strict laws insofar as plagiarism is concerned, and they go back to the original copyright law itself of that particular country. And what happens is, suppose I have to make a PPT and there's a thank you slide, and I want a picture of a seashore behind, and I pick up something from Google and I put it in. The law there will mandate saying that, listen, you need to give credit to the person whose photograph it is, right? And that's how these days I wouldn't say just the law schools. I think all schools across the world, business schools, legal schools, medical schools, are now focusing on the fact that you need to give credit to the person who's originally placed that on Google. And from what I understand, most of the images that are there on Google have expired or lapsed their copyright age in that sense, and have moved to this, unless the person who originally clicks it says, listen, I don't want a copyright on this, I'm placing it on Google, use it as you want. So those are the two different contexts, but I haven't seen too many people complaining about all of these things, because Google just gives it out for free for everybody. So I don't see a lot of people complaining about this. Sometimes it's just imaginative and nice to have some of these pictures behind. But the truth of the matter is that you're supposed to give them credit.
Thank you. Thanks for that. Hopefully, the people here would be following those things, and given their interest in this domain. So I think, you've been very kind in answering these questions, and I'm sure all of us will go back from this webinar with a much more deeper understanding of these licenses and what we need to do about it. So thank you for taking the time for this one.
No worries. Absolute pleasure. Absolute pleasure.
Any concluding remarks from you, or anything you want to convey or leave with the audience as they?
I'd actually like to sit down and have a conversation with a couple of you guys to understand how really FOSS and OSS really works. And because like I said, I don't have a background on all of these things. So for me to have a better understanding of this, I'd like to understand how the process really works from an engineer's level. So if there's any conference, or if there's any talk by any of you guys, and you guys are okay to have a lawyer on board, please do call me. I look forward to come in and sit down and listen to all of you guys.
Certainly, it would be great to have collaboration with you and take this forward. Thank you very much.
So perfect. Thank you so much.
Thank you. And thanks everybody for joining this on a Thursday evening. Wish you a wonderful day ahead wherever you are in the world. So thanks, and look forward to hosting you again on future editions of the TEMS webinars. Thank you, everyone. Thanks, Prashanth.
Thank you so much. Thank you. Thanks, Arun.
Bye then.